I will try to. I'm trying to convince my lord regarding that translation copy may not necessary, because my lord, the manner of exit.
In every case, it's why this.
The manner of main.
Why every document is required? No. It is only when you ask it will be. No, it won't be like that. Who appears? Yes, Mr. Mahesh, you are ready?
If he is ready, I am ready.
Yes.
May I submit,
First is you are asking for, you are seeking enhancement.
First one enhancement. Second part is negligence, the facts of the case is, the appellant was proceeding in his motorcycle, and the vehicle belonged to respond auto rickshaw came and dashed. The police document, all other documents clearly shows, these auto rickshaw dashed to the petitioner's motorcycle. In the first instance, while admitting the hospital, immediately after the accident, there is one sentence is forthcoming in the medical record to the effect that when he was overtaking another motorcycle, this lorry came, this auto rickshaw came and dashed. The FIR is lodged by another rider of the motorcycle. This auto rickshaw also dashed to that motorcycle also. Only on that count, without having any rebuttal evidence, only insurance company came with this history of this accident. And without appreciating the same, tribunal jumped to the conclusion that there is a 30% negligence on the part of the rider of the motorcycle, because only on one count that medical record shows he was overtaking the vehicle, and this auto came and in a rash and negligent manner and dashed to the motorcycle of the claimant. Only on that count. That medical records is also produced by the respondent insurance company.
The order. First come to the order and come to the finding. Then we will go to the documents.
Issue number 1, Issue number 1 starts from page number 7.
Yes.
At the time of evidence, the petitioner himself, para number 7, examined as PW1, and on his behalf, 2 witnesses named Sunil Kumar GB working.
No. Please come to para number 14.
14.
Para number 14.
As per Exhibit P1, copy of the FIR and complaint, one of the injured person by name Ramesh, who is a rider of another motorcycle, bearing number so and so, has lodged the complaint to the concerned police immediately after the said accident on the same day at about 8:10 p.m. As per the averments of the complaint, on the above said date, time and place, when the complainant was riding his motorcycle, the driver of the app auto bearing number so and so drove the same in rash and negligent manner and dashed against the motorcycle bearing number so and so K05HK. That is the ride petitioner motorcycle. And thereafter, auto against the complainant's motorcycle, and thereby he and the rider of the above said motorcycle has sustained injuries. Exhibit P2, copy of the spot pancham shows the complaint has shown the place of accident to the police and pancham, and the police have drawn the said Maja in the place of accident on so and so date. Exhibit P3, copy of IME report shows that the concerned IME inspector has inspected the above said 3 vehicles, and he has noted the damage caused to the vehicle bearing number K42, K5, HK, but no visible damage found on the vehicle bearing registration number K05ER 5336. According to the opinion of the said accident was not caused due to a mechanical defect of the said vehicle. Exhibit P4, copy of the wound certificate is belonging to one Ramesh, complainant. As per the document, the complaint took treatment at government hospital on so and so date, caused injuries, road traffic. Exhibit P6, copy of the charge sheet. This is important. Exhibit P6, copy of the charge sheet shows that pertaining to this section, after completion of investigation, the concerned police have submitted the charge sheet against the driver of app auto bearing the registration number so and so exhibit P5 discharge summary of Sairam Hospital of the in the column history. It has been mentioned alleged history of RTA in Harovali Kanakpura main road at 6 p.m. collision between the two-wheeler and auto. But the in the statement of response number 1 has mainly contended that the accident took place due to the negligence on the part of the petitioner himself. But while riding the motorcycle and in the process of overtaking a vehicle which was going ahead of it, came to the extreme right side of the road and collided with the auto which was coming in opposite direction and caused the accident. And as such accident in question occurred due to negligence on the part of the petitioner himself. In the oral evidence of RW1, he has RW1 is the insurance company officer, my lord. He's not eyewitness. Reiterated the same. It is seen from the record that the cross of RW1, the learned counsel for the respond number 1 confronted the copy of MLC extract of PW1 and put a question that
what are the injuries sustained by
well,
you?
severe head injury and comminuted fracture of clavicle, fracture of bilateral temporal bones.
Who has taken the claimant to the hospital?
That is not forthcoming. Mostly another rider. But the main question is, Melad, merely because a statement is forthcoming in the medical record that he was while overtaking another vehicle in a rash and negligent manner, the respond vehicle came and dashed. Only on relying upon that he is overtaking.
Why would the hospital authorities record such a statement unless and until it is given by the concerned?
Somebody else, my lord, because he is not in a position, he is totally
what
unconscious.
Steps you have taken? What steps you have taken?
My lord, what?
The claimant has taken.
My lord?
What steps the claimant has taken?
My lord, he is admitted the hospital in an unconscious stage and produced all the medical records. Medical record which shows, my lord, severe head injury.
You are relying on the medical records.
Medical record
injuries and everything. For all the injuries and everything. Why not this one exhibit so and so?
My lord, these are proved in accordance with law because the doctor came before the court and given the evidence regarding the injury sustained. My lord, these are only because, my lord, there is a stray sentence available in the medical records. Without they come with an contention that there is a contributory negligence. To prove the contributory negligence, my lord, there is something is to be proved. My lord, 30% negligence only relying upon that medical history, my lord, according to me, my lord, it is not supported by any legal acceptable evidence. My lord.
Yes.
That
now
is
come to the enhancement. That I understood. An enhancement.
Only on that. My lord, pain and suffering.
Come to that. Where is that?
Quantum, my lord, page number 19, para number 20. Sorry, quantum
table?
90.
Table.
Mostly. Table found in page number 29. My lord, out of 4,26,000, 1,84,770 is the medical bills. My lord, the long period of hospitalization. My lord, the injury found in page number 20, my lord. Page number 20. Well, the disability also may kindly be considered because he lost total hearing loss, my lord, and vision is also blurred. There is a mal.
Yes.
This 29 years boy, now suffering from 42% limb disability resulted in 14% whole body disability. PW3's evidence, doctor evidence is relevant as far as injury and
How many days you was in hospital?
42 days, 10 days first instance, 42 days in second occasion. First is Sai Rama Hospital for 10 days, Ambedkar Hospital for 42 days.
Which year is the accident?
2011.
What is your income according to you? Occupation?
My lord, I am agricultural, also doing petty business. But I said 12,000 is my income.
Accident is on?
2000, that is 14/6/2011. PW3 is the doctor, Milan. He deposed regarding the injury sustained, as well as now what is the condition of the appellant.
Injury is head injury, laceration or right knee and partial tear of right of multiple bilateral temporal lobes and neuroma, right clavicle comminuted fracture. What is the future medical expense that is required?
Melad, 25,000, as per the Dr. Melad, to remove the implants, Melad, he required some 25,000 as per the evidence of the doctor, Melad. Page number, para number 8 of the doctor's evidence, PW3.
Medical expenses, any dispute on that?
1,75,551 is the medical bills produced, Melad. In addition to that, 10,000 is also given. But Melad, incidental 52 days, Melad, it may require some enhancement.
Come to that future earning capacity, which para? Come to the disability.
Yes, Melad. That is a forthcoming in a page number. Page number 27, top of the this line, computation is made. 6,750 into 12 into 16 into 10.
No,
10%.
where is the doctor's evidence with regard to the disability? That I am asking.
Yes.
Come to paragraph 25.
At the time of evidence, the petitioner has got examined PW3 Dr. B.S. Venkatesh, orthopedic surgeon of Sai Rama Hospital, Bangalore. In the examination chief evidence affidavit, PW3 has stated that with respect to the injury sustained by the petitioner in the road traffic accident which occurred on so-and-so date, and the producer and the procedures underwent in their hospital for the fractures, injuries, and he has stated that patient discharged on 25/6/2011 with the advice to undergo regular dressing and to continue antibiotics further. He has stated that On verification of the record, the patient admitted twice at Dr. Ambedkar Medical College Hospital, Bangalore, for facial nerve decompression due to the left facial nerve palsy, for excision of keloid over neck and flap repair under general anesthesia. He has mentioned the complaint of the petitioner. As noted in the affidavit, and he has mentioned the disability found in clinical and radiological examination of PW3 has opined that patient suffers from permanent residual disability of about 42% to the part and 14% whole body disability. He has identified the disability assessment copy, case sheet, X-ray, and the same was marked as so and so.
Court has taken the disability as?
As 10%,
As per the doctor, it is 14%.
14%. Well, as I noticed, my lord, actually, neurological this deficiency is not proved, even though he is suffering from severe head injury and consequential this one disability. Only orthopedic surgeon has been examined. It may be a lapse on the part of the claimant, not to examine the other doctor. That is why, my lord, as far as functional disability is concerned, I am requesting my lord to consider it in higher rate.
What is the multiplier?
Multiplier is 16, 29 years. Well, 4,500 is considered and future prospect is added. Well, it comes to 6,750 per month.
Future prospects, how much it is considered
Plus
for disability of
50%, 4,500 plus 50%, that is 2,250.
No, 10% disability, for that 50% future prospects are considered.
Yes, future income.
That I saw, that we can't give.
Future medical expense 25,000 is awarded, my lord. My main appeal, main contention is regarding the these contributory negligence to an extent of 30%. 30% only by relying upon this one entry without having any rebuttal evidence. It is not permissible. It is my first contention. Second contention is regarding the quantum. My lord, may kindly notice another thing, my lord. FIR is given not by claimant, my lord, because he sustained severe head injury in an unconscious stage. Another rider of the motorcycle, he also sustained injury. He given the complaint, and in the complaint, my lord, no such this content, this sentence and these facts are not forthcoming in the FIR. Immediately, it is given by another rider who also sustained injury. Melad, who has given that history is not forthcoming, Melad. And it is this document is produced by the respondent insurance company, not from the custody of the hospital.
Yes, Mr. Mahesh.
Yes, my lord.
What do you say on the contributory negligence?
Yes. Now I invite your lordship attention to my lord, type at page 12 of the judgment.
Yes.
Exhibit R1, my lord, with reference to R1.
Yes.
Exhibit R1, copy of the medico-legal register issued by the medical officer of Sri Sai Ram Hospital, Bangalore. It is seen that as per this document, the petitioner admitted to the said hospital for treatment on 14/6/2011 at 7:30 p.m. With regard to the cause of the injury, it is shown as under alleged history of accident RTA near Harawalli, main road around 6 p.m. Collision between the two-wheeler and an auto. Two-wheeler was overtaking a vehicle.
Yes.
Malad, this is the first document which has come into force, Malad, at an undisputed point of time. The
Yes.
complaint, Malad, and the investigation, Malad, it will be later. There will be a chance of improving or concocting this thing.
Who was examined in support of that document?
Yes. Then, Malad, in coupled with that, IME report may kindly be looked into, Malad, exhibit P3. That clearly shows that he was trying to overtake another vehicle and went and dashed against the auto which was coming from the opposite direction. Actually, Malad, it should have been 50-50, but the court has held 30%. We are not prepared any appeal. Therefore, Malad, it does not require any.
That is exhibit? IME report.
IME report exhibit P3, Malad.
Yes, what do you say about exhibit P3, Mr. Shastri?
My lord,